Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seesaw. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seesaw.
Hi, everybody, and welcome to the November 2024 edition of the Third Fridays podcast. I really can't believe that 2024 is almost over. We're recording this on a day where if you woke up in the Northeast, you might have been privy to some below freezing temperatures. So really, winter's on the horizon, and 2024 is about to end. And so as we get into the end of the year, sometimes we like to start tracking decisions from the appellate division and the workers' compensation board panels that really help shape how we're going to respond and be more proactive in our practice for New York workers' compensation defense. Before we get into that, last month we had a riveting podcast with Misha Powell. As everybody knows, fraud has been a very, very big topic in insurance defense and construction claims over the last year, with the tradesman's case, with the plentiful lawsuits against medical providers, employee attorney firms, just for all different kinds of reasons. RICO, conspiracy theories, improper filing of claims, false mechanisms of accident, stolen identities, things that you actually think you see on TV but are actually happening in the real world. And as we talked about an article that came up where an investigative reporter was, I guess, looking into the status of individuals who resided at a certain building, what Misha was able to do was connect that building's address to some of her own cases, and she obtained disallowances in those claims, being very aggressive in attacking the mechanism of accident and using this idea that, as employers and carriers in this space, we're here to combat waste. We are here to make sure that the integrity of employment doesn't get taken advantage of. And so that was a great podcast episode. So if you haven't listened to that, go take a look. Today I have a very special guest, my fellow partner, Janis. Welcome back to the show.
Thank you.
So, Jeremy, we have spent many episodes, many discussions going over different cases that, really help shape our arguments. Enjoying being the first people to look at things and then employ them for our arguments in court and how we advise clients in this industry. And we have two different issues today. One that deals with posthumous schedule loss of use and MMI, which you are a very big expert on in our firm, and you give a lot of trainings with respect to schedule loss of use. The other is a very interesting appellate division case that really was decided earlier this year, February, and now over the past few months, we've seen that decision be interpreted in employers' favor with respect to labor market attachment or reattachment to the labor market after loss of wagering capacity classification has been found. So let's start with schedule loss of use and MMI. And so the decision we have for everybody today is a matter of employer Clinton County Chapter NYSA. And so this decision came out from the board panel on October 29th. So less than a month old. And maybe, when I read this, Jeremy, as I'm looking through the facts, it almost seems like a case that we've seen before, right? So can you give our listeners the relevant facts leading up to perhaps the schedule loss of use opinions from the doctors?
Okay, so for this claim, the claimant had an MRI in 2019, finding a full thickness tear. The decedent was eventually examined by both his treating provider and an IME provider. who found the claimant, who assessed the claimant for scheduled loss of use, but they also found that this surgery was medically necessary. The claimant then went on, and before getting the surgery, he passed away. And then the issue of whether he was entitled to a posthumous slew became ripe before the board panel.
Right. And so I want everybody that's listening to really think about those types of cases. It's not like they happen often, but an open workers' compensation claim, imagine it's established or accepted for a scheduled loss of use body part. The claimant is receiving treatment, has recommendations for further treatment, and then passes away, unfortunately, due to an unrelated issue. Now, in most of those cases, or maybe all of those cases, as long as that employee is represented by counsel, we know that we're going to either be in litigation for posthumous scheduled loss of use or receive some type of stipulation demand, because why not, right? What does the claimant's attorney have to lose in making a demand for posthumous scheduled loss of use? So the issue was litigated here because, as you mentioned, there were reports indicating scheduled loss of use for this particular person. And the judge decided that the claimant was entitled to that award, issued the award. Now, the carrier in this case appealed, right? So what were they arguing on appeal, Jeremy?
The claimant had not reached MMI at the time of his death.
Which, it seems like a very basic premise, right? In order to receive a scheduled loss of use rating, you must reach MMI, right? A scheduled loss of use is indicative of first reaching MMI. So, and maybe this doesn't really relate to the actual crux of the analysis or the decision, but put yourself in the shoes of the carrier maybe before the appeal, right? The carrier gets an opinion on scheduled loss of use. How do we go from getting an opinion on scheduled loss of use that the carrier obtained from the IME to arguing that that the scheduled loss of use doesn't apply? Why even get the IME at all? Any thoughts? Because I thought that was very interesting that they went ahead with an IME and then in court are arguing, don't listen to this IME.
The interesting part in this one is the doctor does assess the claimant for scheduled loss of use, but he also concedes that given the findings in the MRI, the claimant would require a surgery. So kind of like two things, a dichotomy there.
Yeah, I think it was very creative because, most of the time, judges like to think that employers and carriers buy the opinions of the IME, right? So the employer and carrier obtains the independent medical examination opinion, and whatever that opinion is solid gold. You can't back away from it. And it really isn't true, because what the actual situation is the employer and carrier are obtaining an independent opinion, right? Like, this is not someone that is on retainer by the carrier, even though many claimants think that they are. This is an independent opinion. And so I thought it was a very creative way for the carrier to now say, yeah, I know that there was a scheduled loss of use opinion, but the claimant did not reach MMI before he passed away. So how did the board panel review that argument? What did they look to come to its conclusion?
Specifically, they looked at the opinion of Dr. Scott, who was the consultant for the carrier, and they found, first of all, interestingly, they didn't even credit the 19% assessed by him, because Dr. Scott relied on a distal clavicle excision for 10% of that. The excision never happened because the claimant never underwent the surgery. They determined that the claimant had not reached MMI prior to his death because the medical opinions were of scheduled loss of use, but did not find MMI.
That's a great point, right? So you have the doctor finding a special consideration apply for 10% as a baseline because this claimant was eligible for a distal clavicle excision, right? And it really hurt their side because that special consideration would only be applicable if he had the excision, if he went through with the procedure. So it's almost as if that if the range of motion was the only thing that led to the schedule loss of use opinion, the claimant might have had a better argument that he reached MMI prior to death, right? But not having the surgery, saying that you have schedule loss of use attributable to that surgery becomes problematic. So the board panel basically says that since you were recommended to have a surgery in order to reach MMI, and you didn't have that surgery, you weren't at MMI prior to passing away, and therefore you are not entitled to a schedule loss of use award. How does that affect how we handle those types of claims, right? Schedule loss of use case, untimely passing, unfortunate passing due to unrelated causes. How should we handle that going forward?
From my point of view, we should first be litigating whether the claimant is actually at maximum medical improvement prior to determining what the schedule loss of use is. We shouldn't even get to schedule loss of use if he's not at MMI.
Yeah, that's kind of, I think as people hear this, maybe if you have a lot of experience in this industry, you kind of think that that's very normal, right? Litigating MMI before you reach schedule loss of use. But if you think about it in the context of a regular claim, it's our side that's most often trying to prove that the claimant has reached MMI. Like, you're done with treatment, right? From a curative standpoint, it should only be palliative. You've reached MMI. But in this case, you're almost arguing that the claimant hasn't reached MMI, because if you can argue that successfully, then you don't get the permanent impairment award associated with the MMI finding. So litigate MMI even if your claimant has passed away due to unrelated reasons, because if you can be successful there, you might not be eligible you won't be eligible for the posthumous schedule loss of use. Yeah, that's a really, really good, great point, and a good refresher on not just, MMI and schedule loss of use, but using a very rare situation to kind of reinforce a good topic. Okay, so that's kind of in your wheelhouse, Jeremy. I think that everybody knows that you have the skills and the experience with that particular topic as a subject matter expert in our firm on that. The other case that you brought to my attention has to do with something entirely different, right? So take us back to February of this year. The appellate division decides a case, interesting one, on reattachment to the labor market. And for everybody interested, the case is Digbasanis, I think I'm pronouncing that correctly, Digbasanis versus Pelham Bay Donuts Incorporated. So for my friends out there that have recently moved to Pelham, and if you're listening, go support Pelham Bay Donuts if they're still around. But let's get back to the topic at hand. What happened in Digbasanis versus Pelham Bay Donuts?
So this is pretty much a unique situation in that the claimant, at the time the claimant was classified or found to have a loss of wage earning capacity, he was not attached to the labor market.
Okay, which that is something that's becoming more prevalent, right? Some background for everybody. The relevant section 15 was amended, less than 10 years ago. But before that, classification wasn't so much of a problem for employers and carriers, because if you were to find that the claimant had a permanent partial disability through loss of wage earning capacity, then you could still push labor market attachment as a defense to continuing awards, wherein the claimant would have to prove, an ongoing reattachment with independent job search, with vocational rehabilitation, attendance at a full-time accredited institution, basically to mitigate the responsibility to pay awards that are designed to say you cannot work by showing that you are at least trying to enter the workforce, help out the economy, so on and so forth. And, less than 10 years ago, the statute changed. The statute was amended to say that once a claimant is classified, there would be no requirement to show ongoing attachment to the labor market. Or so we thought, right? So in Pelham Bay Donuts, we have a situation where the claimant was classified with a 70% loss of wagering capacity in May of 2019. Found unattached to the labor market, so no award. Now, imagine you're in this case, everybody, where you are a claimant, you're at the end of your case, you're found to have a loss of wagering capacity, but you're not attached to the labor market, so you're not going to get an award. So all that time you've been relying on this workers' compensation system for a retirement program benefit, and the gravy train stops. So what are you going to do? Well, just 4 months after this claimant was found to have a 70% loss of wagering capacity, he returns to work, right? Which just goes to show you how screwed up the idea of loss of wagering capacity is because if the employer and carrier are successful, then the claimant realizes that he or she has to actually go back to work, right? The gravy train's over. So he returns to work, but of course he returns to work at a wage less than what he was making prior to the accident. So he's able to prove that he has reduced earnings that are causally related to the accident. That means that the carrier makes up 2/3 of the difference with a reduced earnings award. What happened after that? So he gets the reduced earnings award, this Digbasanis fellow. How did the case play out after he gets the reduced earnings award?
So he stops working on March 16th. He claims it's due to the pandemic and his back hurting. He also gets a medical report from a new provider. They go to a hearing. The law judge finds that the claimant's separation from employment was involuntary and continued benefits. However, the board panel decision looks at it and says, no, he voluntarily removed himself from the labor market. And that's how we end up in the third department.
Yeah, I mean, I know it's over 4 years ago, but March 16th, 2020, I don't think anybody is stopping work at that early of a date because of the pandemic. Maybe you are. But I have my jaded ears and eyes. I don't think that you've actually stopped working because of the pandemic on March 16th, 2020. But the board rules that you stopped working for reasons unrelated to the accident, right? Even assuming that you did, right? Like assuming that you stopped working with the pandemic, that has nothing to do with your work accident. And so, okay, you're not entitled to an award. The claimant appealed that decision from the board panel to the appellate division, and the appellate division issued a ruling that should help every employer and carrier in our great state of New York. What did the appellate division decide in February 2024?
They stated that the claimant has an ongoing obligation, even if he reattaches, to provide continued proof of attachment in perpetuity, essentially. And in doing so, they look at the statutory language of 15.3W. Interestingly, it states that in certain cases of permanent partial disability, compensation shall be payable during the continuance of such PPD without the necessity for the claimant who is entitled to benefits at the time of classification to demonstrate attachment to the labor market. For the amended statute to relieve a claimant of the burden of demonstrating ongoing attachment, the claimant must have been classified initially as PPD and found to be entitled to a loss of wage earnings compensation award.
Yeah, so it's like, if you can successfully find the claimant unattached to the labor market at the time he or she is classified, it's not just I have to show reattachment once, right? You have to show ongoing reattachment in order to get the balance of your award.
So the even more interesting part of this is I believe he was actually working at the time of classification. So what the third department looks at is he's not entitled to the PPD at the time of classification because he's working. So he's not entitled to the award. So he has to prove ongoing attachment if at some point he becomes entitled to the award. Even more interesting. So if a claimant that's working and not entitled to it still can work to our benefit. because he's not entitled to that PPD award at the time of classification.
Really, really good stuff. And so, February 2024, this decision comes out, and, it does take a while for it to be applied at the trial level, right? And as we're monitoring and going through it, we start to see some board panel decisions that now cite this Digbasanis claim, right? Even decisions that are 3 months old, they're starting to cite Digbasanis. I'm looking at one from August of this year where a claimant was found not to be attached, and the board panel specifically cites Digbasanis, noting that if there was a specific ruling that the claimant was voluntarily removed from the labor market and or not attached to the labor market, the claimant is not entitled to benefits at the time of classification. As such, the claimant would have to reattach at some point in order for indemnity awards to become payable. The board panel is not disproving or not misapplying Digbasanis in a way that we don't know yet. So how would you take Digbasanis and, the subsequent board panel decisions that are citing it into context for the types of claims that you're working on today?
All right. So in any case where the claimant's not attached to the labor market at the time of classification or somehow becomes entitled to an LWAC award later, I would raise continued attachment in perpetuity and ask for continued proof of attachment even after they reattach post classification.
Yeah, it's almost like, starting at the LWEC attachment argument, right? Most people think of LWEC as like, this is your final opportunity to really litigate everything, and reinforcing that labor market attachment position, because not only are you fighting for the fact that we shouldn't have to pay this, this ridiculous long award because there's this unreasonable proposition that a claimant can't ever go back to work for a sprain in a lot of these cases. If you can secure the no attachment finding at LWEC classification, not only have you helped the employer or carrier tremendously in the short term, you might even argue that you have a better position going forward, because as a non-self-insured client or a case that doesn't have an ongoing third party, you may be able to prevent ATF deposits, right? If you can keep litigating attachment, then there would be no present value of benefits due to the claimant that would now have to be deposited into the aggregate trust fund. You would have better settlement positions because the claimant, even though his time is up for treatment, he now has to continue to prove indemnity if he's originally found unattached. And then, like you said, right, it just allows you to, I think, not give up after the claimant's classified.
I agree. And I think even when we step, let's say, to like a 15% LWEC because the claimant's working for us, but then he goes and gets his surgery later, you don't have a position for him anymore. And then you can say, okay, he still has to reattach. Yes, he may be entitled to an LWEC now, but he has to provide continued proof of attachment because of the fact that he didn't receive the PPD award under 15.3W at the time of classification, which is all that matters.
Right. So you could also attack that multiple ways, right? Like if he has a surgery post-classification, he's going to be awarded temporary total disability. You can litigate attachment after temporary disability all the time. But yeah, the ongoing duty to mitigate the carrier's remittance of indemnity benefits post-classification is something that, when we're looking at this decision in February of 2024, there's always a little bit of shakiness as to how the board is going to use it, right? Now, not to say that the board disavows appellate division case law, because they really can't, but choosing to start to cite it is very, very important as a development in the practice of workers' compensation defense as it relates to attachment. So, two cases really on the radar for the past few months coming to fruition. I know now you're involved in some cases where attorneys are submitting Dig Basanis and some of these subsequent board panel decisions for review from trial judges.
Correct. Right? We had a claimant where the claimant was found non-attached at the time of permanency. Claimant subsequently reattached. We appealed. We lost the appeal. Claimant thinks he's just scot-free now. That's the way it was for a long time. We filed an RFA2 recently. The board has listed it for a hearing in the next week, so we'll see what happens.
Very, very good teaser to end it, right? So we might have to have a follow-up podcast after next week's hearing on that claim that you're speaking about. And, you know, this is the kind of thing that we do. I mean, I don't want to beat a dead horse here, but I just want to remember the first podcast we ever did here on Third Fridays, where we decided that, you know, to be a fly on the wall for all the shop talk that attorneys discuss, right? It makes so much sense for our clients to have a window to see how these types of cases are really worked. And to go from the place of, thinking that every case is litigated the same way, boom, boom, boom. New York workers' compensation defense is changing all the time. And so you really need the most creative attorneys to defend these claims as the law changes and as the law gives you opportunities that you have to take. So very, very good insight. Jeremy, thanks for being on the show today. So for Jeremy, Janis, my name is Christian Cison, reminding you to defend from day one.